Let's go to Section 4 of your Rule 111, Effect of Death on Civil Actions. We are talking here about the death of whom? The death of the accused. And if you're going to read carefully your Section 4, it actually contemplates of 4 situations or 4 scenarios. The first situation is, what is the effect if accused dies before arraignment? Second is, what is the effect of the death of the accused on the civil aspect if it happens after arraignment? But what is an arraignment? Answer can be found in your Rule 116, Arraignment and Plea. Before we read Section 1, ito ang tandaan nyo ha, tandaan nyo to, that pag nagkakaroon na ng arraignment, it means that there was already a determination of probable cause. It means that there was already a determination of probable cause. Kung yung kaso dumaan ng preliminary investigation, because not all cases go through a preliminary investigation. So, kung yung kaso dumaan ng preliminary investigation, then what will happen next is that the fiscal or the investigating prosecutor will prepare a resolution. And if together with that resolution is an information, then that means that according to the investigation conducted by the fiscal, there is a reasonable ground to believe that a crime has been committed and that the accused is probably guilty of that crime. Again, kung meron ng resolution at kasama ng resolution is an information, then that means that according to the investigation conducted by the fiscal, there is a reasonable ground to believe that rape has been committed and Mr. Vong Navarro is probably guilty of the crime of rape. Kaya pagkatapos na kay fiscal, what is the next step? Iaakyat na yan sa korte. At pag umakyat na yan sa korte, either in the MTC or in the RTC, depending on the crime, ang first na gagawin ng korte is it will conduct an arraignment. Kaya if you're going to read your section 1, that is the reason why that arraignment is conducted by the court where the complaint or information was filed or assigned for trial. Next, what happens during the arraignment? Sa practice, mabilis lang yang arraignment. That is siguro 3 to 5 minutes. Because what happens there is, patawagin si accused, papatayuin, and then the complaint or information will be read to the accused in a language or dialect known to him, and the court will now ask him what is his plea. Is it guilty or not guilty? Kaya kung ikaw yung abogado ni accused at may hearing, huwag kang mag-alala kasi number 1 ka sa calendar, uunahin ka ni judge tatawagin kasi mabilis nga lang yung arraignment. Sandali lang yan. Babasahan lang si akusado. That is the reason why pag binasahan si akusado, dapat present si akusado during the arraignment. That is a must. And what is the reason or what is the purpose of the arraignment? The answer can be traced back to the Constitution, because one of the constitutional rights of the accused, and relate that further to your Rule 116, is that the accused should, or the nature and the cause of the accusation should be known to the accused. The accused has the right to be informed of the nature and the cause of the accusations against him. Balik tayo. Tuloy tayo sa Section 4. The number 3 scenario is, what is the effect if the accused dies during the pendency of the criminal action? Meaning to say, during the trial or during the presentation of the evidence. And last is, what is the effect if natapos na lahat ang kaso, nagkaroon na ng judgment? So first scenario is before arraignment. So what is the effect if accused dies before arraignment? Then as far as the criminal aspect is concerned, of course, it is extinguished or it will be dismissed. Kasi hindi naman pwedeng yung kasalanan ng tatay is kasalanan ng anak. Hindi pwedeng ipapalit yung anak bilang akusado. But how about the civil aspect? As far as the civil aspect is concerned, you can file it against the estate of the deceased. Section 4, the last paragraph is very clear that if the accused dies before arraignment, then the case shall be dismissed but without prejudice to the filing of civil action by the offended party against the estate of the deceased. How about if accused dies after arraignment? So what happens to the civil or to the criminal aspect? Of course, common sense, the criminal aspect is also extinguished. But how about the civil aspect? Also extinguished. Take note ha, also extinguished. Basis, that is your section 4 of your rule 111. The death of the accused after arraignment extinguishes the civil liability of the accused. Next scenario. What if accused dies hapon nung siya ay binasahan, or during the mediation, or during pre-trial, or during the presentation of evidence? Then what is the effect? Again, as far as the criminal aspect is concerned, it will be extinguished. How about the civil aspect? It will also be extinguished. Basis again is your first paragraph of section 4, the death of the accused extinguishes the criminal aspect as well as the civil aspect. But take note ha, yung pinag-uusapan natin dito na civil aspect, huwag niyong kalimutan na ang source niyan is the delicts, the act or omission punished by law. Diba? Sabi nga natin, if a person has an obligation, there are at least five sources of his obligations. And that sources may be law, contracts, quasi-contracts, or quasi-delict. Kung ito ang sources ng obligation, ng civil obligation ng tao, then hindi ito na i-extinguished. But if this is the source of the civil obligation of the accused, then that is the one extinguished because of his death. Let's go to the last situation, that is after judgment. That means that a judgment has already been rendered or a decision has already been made by the judge. So what happens if the accused dies after judgment? As far as the criminal liability again is concerned, that is extinguished, common sense. But how about the civil liability? It can be filed against the estate of the deceased. Basis, that is again your section 4. This is the third paragraph. But take note that we are talking here about a judgment that is considered final. A final judgment. Kasi kung yan ay judgment lamang but hindi pa final, then what is the effect? It is extinguished. But if it is already a final judgment, then you have that option to file it against the estate of the deceased. But when can you consider a judgment final? Ito. Pag si judge is nag-render ng decision, either the MTC judge or the RTC judge, take note that that is not the end of the world. Kasi ikaw akusado, you still have a remedy. You still have an option. And your option is to file your case, to appeal your case rather, to the Court of Appeals, or kung sa MTC yan, to the RTC, or you can go directly to the Supreme Court, depende. But if you accused did not file an appeal or did not avail of those remedies, then that is the time that the judgment will be considered final. If you read this if you relate this to your Section 2 of your Rule 36, this is your civil procedure. If no appeal or motion for new trial or reconsideration is filed within the time provided in these rules, then the judgment shall become final. The judgment shall become final. So when a decision becomes final, what will happen next? According to your Section 8 of your Rule 120, this is your criminal procedure, is it shall be entered. Entered where? Entered can be found in your Section 2, Rule 36, Civil Procedure. It will be entered in the Book of Entries of Judgment. Yan yung libro kung saan nakasulat lahat ng mga final judgments, like a listahan ng mga utang. And who will enter? It is the clerk of court. What will be entered is the dispositive part of the judgment, and it will be signed, of course, by the clerk of court. So let us just say that a decision was rendered around August by the MTC or RTC judge, and that decision was not appealed by the accused. There was no appeal, there was no motion for new trial filed or MR filed by the accused. So that decision rendered by the judge became final on August 8, 2022. So this is the date of finality of the judgment. But sa totoong buhay, kahit ito ay naging final na noong August 18, and the next step is it should have been entered by the clerk in the Book of Entries of Judgments, is sa realidad nga is that will not happen because your clerk of court is of course busy with other works. Hindi lang naman yan ang kanyang inaatupag. So usually ang nangyayari is yung decision that has become final, it is not entered on the day itself kung saan naging final siya, but on some other day. Let us just say that this decision, which became final on August 18, was only entered in the Book of Entries of Judgment on September 21, so more than a month after. So in this case, you already have two dates, August 18 and September 21. Malilito ka na. So ngayon, ano ang date of finality mo pa rin? Because the decision that became final on August 18 was only entered on September 21. Take note that if you're going to read your Section 2 again of your Rule 36, ano ang sinasabi dyan? Even if this decision, August 18, was only entered on September 21, the date of entry is not September 21, but the date of finality. The date of finality of the judgment shall be deemed to be the date of its entry. Kaya ito lang ang tatandaan mo na date. Let us now go to substitution. Substitution of what? The substitution of parties. Take note that this concept of substitution can be found not only in the criminal procedure but also in your civil procedure. May magtatanong sa inyo, teka lang attorney, akala ko ba walang substitution sa akusado pag siya ay namatay? That is correct. But take note that what we are talking about here is the substitution of parties in the civil aspect, sa civil aspect. So, pagdating sa criminal aspect, syempre walang substitution because hindi pwedeng ang kasalanan ng tatay ay maging kasalanan ng anak. But pagdating sa civil aspect, of course, there can be a substitution, and who will substitute? Who will substitute is either the estate of the accused or the legal representative of the accused. But substitution will only happen if the civil action is considered an independent civil action. We discussed this already. And substitution can also happen if yung civil action is na-reserve and it was filed after the death of the accused, and that source of that civil aspect is law contracts, quasi-contracts, hindi kasama si delix kasi pag kasama si delix, that is extinguished and quasi-delix. Take note ha of the substitution. If you're going to compare that to your civil procedure, that is your section 16, rule 3, take note that sa civil procedure, kung sa criminal procedure, there is a death of the accused and then substitution happens, here in your civil procedure, hindi kailangan death ng defendant because it could be the death of any party to a pending action. So whenever a party to a pending action dies and the claim is not extinguished, then there would be a substitution. And who will substitute? It will be the legal representative of the deceased. Ano ba tong claim is not extinguished? For example, the case is a personal, purely personal, like yung action for support or yung action for annulment or for action for legal separation. That is a very personal action. Then, in that case, the claim is extinguished. In that case, the claim is not extinguished. Therefore, there could be no substitution. But if the claim is not extinguished, like yung mga action against the properties, then substitution happens. At pag nagkaroon ng substitution, take note that there is no need for the judge to issue summons because what the judge will do is it will issue an order. It will issue an order, and in that order, it will require the legal representative to appear and be substituted within a period of 30 days from notice. So pag binasa mo yung sa criminal procedure and sa civil procedure about the substitution of parties, more or less they are the same.